I can hear you. Okay, you need to unmute there, Mr. Perry, and then start your video.
Okay, Judge, can you hear me?
Yeah, I can hear you.
I do not know why my video is not on.
Oh, okay, it's not. You're using a different link than we're familiar with.
I am?
It comes up at CyberLink UCAM 5.
Oh,
You
sorry.
start your screen.
I'm gonna close and redo this. Hold on.
Okay, all right. Ben, you can go ahead and pause the recording there. I've got it paused on Zoom.
Okay.
And then, are you able to hear me down there by the bailiff's desk okay?
Yes, sir.
All right, I'll just give you the signal when he's back on.
Okay.
Mr. King, I told Marcia I'm going to be down here again tomorrow, but I'm going to go ahead and do all the hearings by Zoom except that suppression. By the way,
Yes, sir.
Recording in progress.
got the Zoom recording started again. Okay, do you need to talk to your client before we go on and start this, Mr. Perry?
Judge, I don't think so. He understands that the court
Okay.
has called this hearing to remove any.
Okay, so you've been able to talk with him before the hearing?
Yes.
Okay, good.
Well, you understand that, right?
Yes, that is my understanding, that the Ligon token law will not apply to my case.
Right.
Okay, well, then we'll go ahead and get started formally then. So this is State of Ohio versus Borough Lee Reinheimer. This hearing is being conducted by Zoom due to my and being out on a family member's medical issue. And so it is being conducted by Zoom, and Mr. Reinheimer is appearing from the Highland County Jail. That is you, Mr. Reinheimer?
Yes.
Okay. And the record will reflect that Mr. Perry is present, but there's a problem with his video connection, but he is available by audio, and I do recognize his voice being the person participating. Assistant Prosecutor King is present for the state, and I believe Ms. Reinheimer is also observing as a witness, or as an observer, I should say. Now, the defendant entered a plea of guilty on September 30th of 2021 to rape under 2907.02A2, first degree felony. And at that time, he was sentenced to a term of 10 years mandatory, which was an agreed sentence. And also, because it was indicated on the guilty plea that rape and coach law applied, he was also informed that 10 years would be a minimum sentence, and that it could be a maximum of 15 years or half of the 10, because that's what's provided for by rape and coach. Subsequent to his being processed into the Department of Corrections at Orient, the court received a communication dated October 13th. Actually, I didn't receive it until October 29th, according to the clerk's stamp, indicating that the date in the indictment indicated the offense was committed under different sentencing law. So I pulled the file, looked at the indictment, and I believe that is the case. That rape and coach would not apply, and Mr. King, on behalf of the state, you're in agreement with that?
Yes, Your Honor.
I assume you are as well, Mr. Perry?
Yes, sir, I am, Judge. Thank you.
All right. Does either counsel wish to say anything else? The intent of the court is simply to vacate that portion of the sentence and put on an amended sentencing entry that deletes that. So anything further from the state?
No, Your Honor.
Okay. Mr. Perry, anything else?
Nothing further, Judge. I appreciate the court's decision just to remove that from the original sentencing order, if that's what you're saying. So I think that would satisfy us.
Right, that's what we'll do. All right. So, Mr. Reinheimer, let me ask you this. You're still okay with the original plea agreement, and this basically just makes your sentence a flat 10 without any possibility of it being extended. So do you have any questions or anything you would like to say regarding that? Your attorney's already spoken for you, but if you have anything you'd like to say, I'll hear it.
Right. No, Your Honor, I understand completely what is happening.
All right. Well, then it's a judgment order of the court that that portion of the sentencing entry in this case was filed, I believe, on September 30, 2021, that indicated that the 10-year sentence, mandatory sentence, was a minimum, and that there would be a maximum of 15 years under the rape and coach law. That is hereby vacated. And all other aspects of the original sentencing entry remain in effect, including the designation as a sex offender, registrant, the court cost, mandatory post-release control for 5 years. All of the rest of the entry is to remain the same. And so, Mr. King, if you would prepare an amended entry that just deletes that portion of the order, and then I'll sign that maybe tomorrow or next week. I'll be in the office next week.
Yes, Your Honor.
All right. All right. Is there anything further from counsel, Mr. King?
No, Your Honor.
Ms. Perry?
Nothing further, Judge. Thank you.
All right. Thank you for letting us do this by Zoom. So I didn't want Mr. Reinheimer just to have to be sent back and brought back again. And so handling this by Zoom, it makes it a lot easier. So thank you, Mr. Reinheimer. Mr. Perry.
Thank you, Judge.
Thank you, Mr. King. Thank you.
Ms. Dixon.